hearing in the appeal MS Palestinian Territories against the Secretary of State for the Home Department.
Good. My Lord, my Lady, good morning. Can I ask your Lordships and your Ladyship to return to paragraph 8 of Schedule 2, please? And what I will seek to do is try and put that provision and the decision we're considering, the decision under 82.2h, into its overall context under the 1971 Act, and then have another stab at explaining the process by which that process is operated. And I took the court yesterday to paragraph 8.1 and the requirement that triggers the power to set removal directions being a decision to refuse leave to enter in relation to a person arriving in the UK. Turning to paragraph 9, I then sought to identify the two requirements that, or the two preconditions before the power to make removal directions in relation to illegal entrance arises, and that is one, that the person has to be an illegal entrant, and two, that he is not given leave to enter or remain. And we see a similar pattern in, for example, in paragraph 10a or in paragraph 12, all of which, of course, are also decisions which are referred to in section 82.2. That, in our respectful submission, has to be read together with, or in light of, the powers derived under paragraph 16.2, namely the power to detain a person pending one of two decisions, either the decision whether or not to give removal directions or the removal in pursuance of such directions, where there are reasonable grounds for suspecting that a person is someone in respect of whom directions may be given. So there needs to be, at the very least, reasonable grounds for suspecting that removal directions under paragraphs 9 and 8 can be made, and then Parliament there recognises the two-stage process which the Secretary of State sought to identify in the printed case, namely the in-principle decision whether or not to give removal directions, and secondly the decision as a result or as a consequence of that in-principle decision to remove in pursuance of them. Now, the next provision I would ask your Lordship and your Ladyship to look at is paragraph 21.1, which is the power to grant temporary admission, which refers to a person liable to detention or detained under paragraph, amongst others, paragraph 16.2, may, under the written authority of an immigration officer, be temporarily admitted to the United Kingdom without being detained or released from detention. And in our respectful submission, one has to look at this whole scheme together to work how the submissions my learned friend made in relation to the decision would play out. Because, of course, while it seems clear that paragraph 16 and 21 give a power of executive action where there are grounds to suspect that a person is removable, up to the date of removal in pursuance of any removal directions, see 16.2b. If my learned friend were right, of course, the decision of an appeal tribunal against a decision under 82.2h on the basis that there are practical obstacles to removal would also deny the power to detain or the power to grant temporary admission, which we respectfully submit, and I will come back to this, is contrary to the scheme identified by the House of Lords in the case of Kadir, and is contrary to the intention of Parliament as expressed in section 67 of the 2002 Act. But before I get there, can I, just looking at these three provisions, then seek to return to something I attempted yesterday afternoon, namely to explain how that process works and why there is a multiple, while there are multiple decisions which lead which lead ultimately to the decision that forms the decision under appeal, the decision in principle, to remove an individual from the UK. And there are perhaps two places in the authorities where this is set out. One is the Border and Immigration Agency's enforcement guidance at Chapter 7, which your Lordships and your Ladyship have at Volume 7, tab 76, or in the case law in Kariharan at paragraph 20, that is Volume 4 and 47, at tab 47. And both of those identify, on the basis of the case law I identified yesterday afternoon, that there is a two-stage process before the first document, namely the IS 151A, the notice of illegal entry, is served. And that is, the process there is, one, a decision that the person is in fact an illegal entrant, and then two, a decision that it would be fair to treat the individual as an illegal entrant and to serve a notice of illegal entry on him. And that second stage then leads to the service of the Form 1, IS 151A, which in this case was served on the date of arrival, the 25th of April 2007, which the court has as Appendix 37. And the importance of the IS 151A is, as the court will see from that document itself, is that it notifies the individual of his liability to detention under paragraph 16.
What page is it again?
This is paragraph 37, my lord, of the...
Page 37. Page 37 of the appendix.
Page 37 of the appendix, my
Yeah,
lord.
thank you. What is IS 150, Immigration Service? Is it a prescribed form?
My lord, as I understand it, it's an internal form. Yeah. It's not prescribed by statute, as I understand it. But it is the IS 151A, B, and D in this case are a prescribed series of forms which record or provide notice of various stages of the removal process, my lord.
And you referred to Kariharan. What paragraph was it?
Kariharan was at paragraph 20, my lord. This is 4 at volume 4 at tab 47, where the court, of course, under the old scheme, but explained the process by reference to Kawaja and Uluyol and Kakmak as two-stage process.
I mean, what's the alternative if you decide it's not fair to treat someone as an illegal entrant and not fair to serve a notice on him? What's the alternative?
Well, my lord, the Secretary of State always, of course, has a discretion to allow an individual to stay. And, for example, there was and still is a policy where somebody who's resided in the country for more than 14 years, on whatever basis, should not be subject to enforcement action. So if somebody is only discovered, let's say, hypothetically, 20 years after he first arrived here as an illegal entrant, then it may well not be fair to subject him to the powers of detention, temporary admission, and the whole process.
So what do you do? What's his status?
Well, he would then be, as a result of the concession, or the policy, would be considered under that policy and granted the status that goes with that policy, my lord. Yeah, but he wouldn't be an illegal entrant, and therefore...
It just seems to me a bit artificial to say that there's a separate stage from the decision whether or not to give him some other status.
Well, this is what happens. This is a person who's discovered to be an illegal entrant, and the day he was discovered, he's served with this.
In this case, my lady, yes.
But that must be quite frequently, mustn't
my
it?
lady, yes. And there, of course, as the case, the Court of Appeal in Kariharan records, it's quite difficult and, as your lordship puts it, possibly quite artificial to separate out those decisions. But for the decision maker, the instructions are, and the guidance from the courts is, that it is a two-stage process which results in this form, namely, is he an illegal entrant, yes or no? And if the answer is yes, is it fair to treat him as an illegal entrant?
Yes, it's not actually... I mean, what's slightly elusive is that sounds as if you're changing his legal position. It's not. Well,
No.
the decision is actually not a decision not to change his status as an illegal entrant. He's already an illegal entrant.
He is an illegal entrant,
Yes.
and the
But-
decision is one that records effectively a refusal to change his status.
Yes, exactly.
Namely, we now treat you as what you are.
But it's not really, I mean, if one talks about it in terms of a decision, of course, it's not one of the immigration decisions that
No,
are
my
listed in section 82. So it's merely the recognition of the fact which the immigration officer has identified and the giving notice of the potential consequences of that fact
Well,
to
it
the
is.
person so identified, isn't it?
Yes, my lady, but of course necessarily so because of the quite draconian consequences that flow from the decision
Exactly.
and enabling access to the High Court on judicial review if that were thought necessary in relation to either detention or temporary admission, my lady, yes.
Or the identification of somebody as an illegal entrant. Because Kawaja says that's a jurisdictional fact.
My lady, yes, or that, yes.
But you have to start with that before you can get on to anything else.
My lady,
Is
one
that right?
has to start with that, of course, to even get into paragraph 9 of Schedule 2, because if you don't have that notice, then there has been a decision not to treat you as an illegal entrant, and therefore paragraph 9 is inoperable, and therefore there is no power. Paragraph 9 of Schedule 2, my lord. Because, of course, that requires the individual to be an illegal entrant before it can operate.
Yes, I mean,
And
in theory, in order to comply with paragraph 9, all you have to show is that nothing had been done. He hadn't been given leave to enter or remain. But in practice, the fact that nothing is going to be done is recorded in this document.
My lord, no, it's the other way around.
Depends what the nothing is.
My lord, yes.
Well, nothing has been done by way of giving him leave to enter or remain. He is, as my lady said, jurisdictionally an illegal entrant, and you don't have to make him one. He is one. If you don't give him some other status, then that applies. And it's very convenient, I can see, to have something which records the attitude of the authorities, but to turn these into steps which suggest some sort of change in status is a bit odd.
My lord, but I think it's important to bear in mind that, as in this case, these decisions, this first decision is made relatively swiftly, and therefore the decision not to issue an IS 151A is not a decision to say you will be granted leave or you have been granted leave. It is a decision to say we think it would be unfair at the moment to treat you as an illegal entrant while we consider whether to grant you any status. So in that sense, it doesn't quite reach as far as the proposition your lordship puts to me would put it. Namely, no decision has been made to change his status yet from illegal entrant, but it's been considered for reasons of Article 8 or for other reasons of policy to not treat him as an illegal entrant and therefore not expose him to the consequences that flow from paragraph 9,
Well,
16.
but they could treat him. I mean, they could after thinking. It's just a decision not to make a decision. It's just a postponement of the critical decision. But I mean, during that period, he must actually remain an illegal entrant. At the end of our thinking about it, they might decide to serve the IS 1A.
My lord, as I understand the process, the Secretary of State certainly treats the process as the liability detention only be triggered once that document has been served, because of course otherwise legal certainty would deprive him of the ability to know.
A combination of jurisprudence and the essential fair-mindedness of the administration has suggested that before a person is actually liable to be picked up and detained under paragraph 16.2, he should be warned of that fact.
My lady, yes.
That's what it boils down to. So an extra step, which
My lady,
isn't
yes.
in the statute, has been introduced into the process.
No, my lady. Yes, that's right, but that's how certainly the courts have to date, and the Secretary of State have treated the reference to illegal entrant in 9 as a reference to somebody who is to be treated as an illegal entrant, rather than somebody who, by definition of statute, is one.
But there's no statutory basis for this particular step, is there?
My lady, no. There's no requirement, paragraph 9, to...
There's nothing in the statute or the delegated legislation between the fact of being an illegal entrant and the liability to detention and
apart, my lady, from the requirement that there need to be reasonable grounds for suspecting that removal directions can be set.
I hadn't got anywhere near removal directions yet. That's the next document.
My
Oh,
lady,
no, it isn't the next document. The next document is the next document is the decision in principle, as you call it.
My lady, yes. But of course, paragraph 16 sets as a requirement that there are reasonable grounds for considering that removal directions may be set. So that is a statutory requirement, which does require the decision maker to look at paragraph 9, whether it requires him to make the decision the way the Secretary of State currently makes them, guided by the courts, or differently. But the decision maker, before he exercises his power to detain under paragraph 16, needs to consider whether there are reasonable grounds for considering that the individual is liable to removal directions, and therefore, in my respectful submission, is required to consider not only the question of illegal entry, but also the question of reasonable grounds for suspecting that he will be refused leave to enter or remain on the facts as they are known at any point in the decision-making process. But that's what we say the importance of that document is, and as we see in this case, it is issued at the date, here it was issued on the date of arrival, the decisions were effectively contemporaneous, and it is only after that stage that the process for the second requirement of paragraph 9, namely whether to refuse leave to enter or remain, is undertaken, and it is in that context where investigation, as we've seen here, through interviews, through witness statements, and the like is undertaken to consider whether there are grounds on which this individual ought to be granted leave to enter or remain, such as under the 1951 Refugee Convention, or under humanitarian protection under the Qualification Directive, or any other reason of policy or otherwise. And it is only once that those decisions, those factors have been considered, that and a decision has been reached that no leave to enter or remain should be granted, that decision is communicated together with, in accordance with Regulation 5 of the Notices Regulations, a letter setting out the reasons. And this, the court has at appendix page 38, is the form IS 151B, which is what we call the in-principle decision. Which records the two prerequisites, namely the service of the IS 151A informing the individual of his immigration status and the liability to detention and removal, and then two, the fact that the Secretary of State has decided to refuse claim for asylum and or human rights for the reasons stated in the attached letter. A decision has now been taken to remove you from the United Kingdom. And in our respectful submission, that is the nub of the decision. The decision is one to remove from the United Kingdom. And it is that decision which, in our respectful submission, is the decision referred to in 82.2h, namely the decision that the requirements of paragraph 9 have been satisfied to enable the Secretary of State to make removal directions in relation to this individual under paragraph 8 and 10.
So the decision to refuse the claim for asylum and or human rights is simply part of the grounds for the appeal, not an appealable decision itself.
My Lord, yes, it's not an appealable decision in itself. It is an integral part, my Lord, of the grounds, because, of course, the refusal of leave to enter or remain is part of the decision, and that decision was made on asylum or human rights grounds, and therefore that whole dispute, if one wants to call it that, is subject to effectively two grounds of appeal, namely the one that the decision is contrary to the Human Rights Act, and the decision that removal in consequence of that decision under 84.1g would be contrary to the Human Rights Act or the Refugee Convention.
So it is a decision, but it's not under 82, it's under 84.
No,
My Lord, it forms an integral and important aspect of the decision under 82, but it isn't a freestanding decision under 82, my Lord.
Well, it's got to get within 82 for there to be a right of appeal at all.
My Lady, yes. Yes.
So
That's
the Human Rights and Refugee Convention claims are grounds for determining the appeal.
My Lady, yes. Yes.
Yeah. Why is it not, and there will be an easy answer to this, because you have been talking about there being a decision to refuse leave to enter to this illegal entrant. So why doesn't he have a right of appeal under 82(2)(a)?
My Lady,
I think I know the answer, but I prefer to be told it.
answer, as I understand it, is as was discussed with my learned friend yesterday, that because he is in the country, the decision is actually a decision to refuse him leave to remain rather than leave to enter.
Yes, yes.
And again, in my respectful submission, 82(2)(a) effectively is the link Parliament provided between the decision, the appealable decision, and Schedule 2, because the decision under 82(2)(a) is the decision that triggers the right to grant, to make removal directions under paragraph 8 rather than paragraph 9. And your ladyship will recall that the precondition there is that an individual arriving in the United Kingdom is refused leave to enter, and it is that decision that is considered there. And in our respectful submission, that is, while we are at 82(2)(a), one of the important aspects, of course, of that decision and the way it is recorded in 82(2), in our respectful submission, is that unlike, in our submission, only H, which provides, as my learned friend says, a reference to the mechanism, 82(2)(a) has the same consequences, namely the power to detain, grant temporary admission, and to make removal directions, but it makes no reference whatsoever to the mechanism.
Which is interesting because the regulations, the order actually requires you to specify the place of destination, the country of destination, even in respect of A, doesn't it?
My Lord, yes, yes.
So that that suggests that you can't use the order to define the scope of the decision.
My Lord, it does, and in our respectful submission, it supports our contention that the reference to what my learned friend phrases the mechanism in 82(2)(h) is no more than a convenient link for Parliament to paragraph 9 of Schedule 2, that those two boxes have been ticked, i.e. he is an illegal entrant and he has been refused leave to enter, rather than any more than anything more than that.
Why didn't they simply provide a right of appeal against the refusal of leave to remain?
My Lord, my Lady, that
It would have been so much simpler. And again, there'll be an easy answer to it. But
my Lady, I fear there might not, because I don't know why they didn't. But your ladyship will have seen from our printed case the history of this and the way that the appeal mechanism has changed. And in the 2002 Act, it was decided that, in our respectful submission, that the appeal right should be given to the decision that triggers, effectively the decision that triggers the important consequence, namely the power to make removal directions before those removal directions are made, to enable the tribunal to look at the legality of that decision, both in terms of the Race Relations Act, the Human Rights Act, and public law in general, and the legality of the consequences of that decision in the form of removal directions under 84(1)(g).
Yes. I mean, one can see why that appears to be the appropriate construction. If one had just had the 5 cases by themselves, that's the ones which say a decision by way of directions, one might have wondered whether the words by way of actually meant consisting of. But you say that the decision in A, for example, is quite clearly separate, and in B from the directions. Where do we actually find the need to make a decision in principle, as you've called it? The document IS 151B says it's under Section 10 of the Immigration and Asylum Act 1999, but looking at that section in tab 5 doesn't appear to me to have anything to do with this case, but I may be wrong.
My Lord, no, there are. That is a different decision under Section 10, which is.
Well, why does ISI 151B refer to Section 10?
Aren't there alternatives? There are two headings. And if
Oh, I see.
Yes, my Lord.
people were being sensible, they would strike one of them out.
Yes, I see. Yeah.
My lady, yes, but
It's a decision to remove an illegal entrant.
Right.
my lady, yes, and your lordship will see in section 82(2)G provides for the appeal against that decision to remove under section 10.
Yes.
So they are in the alternative.
Yes, I see.
They're both available. They both trigger the power of detention, as section 10 makes clear, and they both trigger the power to grant temporary admission. And the document is one that, for shorthand, is used to record either of those two decisions.
So we get the distinction between the decision in principle and the later removal directions simply from section 82. I mean,
My Lord, yes, 82,
this is where the requirement for an immigration decision comes in.
My Lord, yes.
By implication, yes.
I mean, in practice, of course, the decision has to be made, but 82 crystallises the need to formulate, together with the notices regulations, to formulate that decision in a particular format in order to enable the right of appeal which Parliament has granted to be exercised and to be effective, which requires, amongst other things, the letter setting out the reasons why leave to remain has been refused under asylum or human rights grounds.
It's interesting that the footnote to a decision has now been taken to remove you from the United Kingdom actually refers to section 82(2)G, H and I,
My lady, yes.
which bears out.
My lady, yes, yes. It's to meet that statutory requirement to set out the appealable decision. And while we are at section 82(2), can I just make a number of further submissions? One is, of course, in our respectful submission, it would be a curious thing if Parliament, as your Lordship and your Ladyship have seen from the printed case, historically has granted no right of appeal in relation to the country under paragraph 8, except for very limited destination appeals, where jurisdiction effectively depended on being able to point to another country that would have the individual, and would now seek to introduce such a right of appeal without doing so through express words. In particular, where, as is common ground and as the courts have recognised, the intention in the 2002 Act was to abolish appeals against removal directions. And this recognition of the intention to abolish removal directions is also recorded in a decision which the court has not yet been taken to, and I don't think I need to take your Lordships and your Ladyship to, but I would commend to the court, and that is the, as far as I'm aware, the only decision fully in point from the specialist tribunal, namely the Asylum and Immigration Tribunal, presided over by Mr. Justice Ousley in KF, which the court has at volume 6, tab 70, paragraphs 13 and 52 to 65. Because in that case, the tribunal had to consider a decision where an adjudicator had allowed an appeal on the basis that the removal of an Iraqi to Iran was not in accordance with the law, and therefore sought to allow the appeal.
So which paragraphs are you referring to again?
This is paragraph 13, sets out the decision of the first instance tribunal, and then 52 to 65, my Lord, where the tribunal records its conclusions on removal directions and the country of proposed removal. And the tribunal notes in paragraph 57, as we have explored in this court over the last day and a bit, that all of this turns on the meaning of immigration decision, and then sets out the understanding of the specialist tribunal, what the immigration decision in this case is, and what it contains and what it does not contain. And it records in paragraph 65 the curious consequence that would arise if my learned friend were right, namely that the appeal would be dismissed on the basis that removal would be unlawful to that country because of the 1971 Act. And therefore not take place, and there would be no risk. Now, the second submission I wanted to make on the basis of section 82 is the point that on the language of the provision itself, there is, of course, no reference to a country of destination, but only a reference, where there is a reference to removal, a reference to removal from the United Kingdom, which again we say emphasises the in-principle nature of the decision, and there's nothing that requires a destination to be stated in 82(2)h, other than the requirement under Regulation 5 of the Notices Regulations to identify a proposed destination in all cases in which the power to make removal directions is triggered. And in our respectful submission, there's nothing in my learned friend's suggestion that there is significance in the fact that there are no separate human rights or asylum decisions listed as appealable decisions in 82. Because, of course, in relation to illegal entry cases and other cases, it is in our respectful submission wrong to assume that these decisions always are made, or that the asylum or human rights claims are always made at the first possible opportunity, and therefore the decisions are always made by reference to an established human rights or asylum claim. Quite frequently, of course, either after the IS 151A has been served, or even at a later stage, be it as a result of the one-stop notice in the grounds of appeal, human rights arguments are raised, which it is right in our respectful submission for the tribunal to be entitled to consider under 84(1)g, even if they have not formed the part of the original decision. And finally, in relation to the decision as it is made and as it is recorded in the in the notice of the decision as it is set out in the appendix at page 39, of course the proposed destination is expressly set out as a conditional on two prior events happening. One, or possibly three. One, that the individual does not appeal, and we know he has appealed. Two, that you appeal and the appeal is unsuccessful, and we're still working on that. And three, that he does not leave voluntarily. It is only once those factors come into play that the Secretary of State considers whether to make removal directions, which in their very nature have significant resource implications in relation to foreign countries, both diplomatic, financial and practical, which can only be made at that stage in our respectful submission because the circumstances of the case, both in relation to the person himself and the country, are of course extremely changeable and therefore time critical. And finally, either of those two contingencies may render the need to make removal directions and the need to exercise the power under paragraphs 9 and 8 of Schedule 2 wholly unnecessary. And that, again, we would say, is re-emphasised by the fact that even in paragraph 8, the country to which an individual is to be sent only needs to be specified at the date of or in the directions, as paragraph 8 says. And it is common ground here both that there has been no removal direction made and it's common ground that the removal directions are not immigration decisions for the purposes of 82.2h.
Well, the directions are addressed to the carrier, aren't they?
Well, yes. And as we see from the IS 151D, which is the document that is served on the individual, it records that removal directions have now been served. That is at the back of the appendix. It's the last document in the appendix.
What is C?
C, as I understand it, my lord, relates to those who are removed as a result of deportation, or breach of a deportation order. If an individual is re-entered in breach of a deportation order, that's when C is used.
Yeah.
But your lordships and your ladyship will see in the 151D that it's made under paragraphs 9 and 10A of Schedule 2 and Section 10. Again, this is the two bases on which it can be made.
Can you just give...
So it has its own tab, my lady. At the back of the appendix, there's a...
You mean it's at the back of the core volume, which of course I don't have...
Oh, my lady, it's
yeah.
back of the core volume rather than the appendix. My apologies. My lady, can I hand up my Leonard Jr.'s copy, perhaps?
Can you spare it?
He will be able to spare the 151D for a moment, I'm sure.
It's all right, it's all right.
I'm grateful.
My lord can spare his. I always keep my core volume in my room so that I don't have to cart all the papers to and fro during adjournments, as you may have noticed. So, but sometimes key documents sneak out of the appendix and into that. Thank you.
And this, your ladyship will see under the side heading removal directions, effectively notifies the individual that directions have now been given, of course, as your ladyship rightly points out, to the carrier, for removal from the United Kingdom by flight, in this case, because it's a sample, understandably, by a numbered BA flight, in this case, at a specific time, on a specific date, to a specific destination. And it is at that stage that the destination crystallises. And it is that decision which, as the form makes clear, no appeal lies, and it's that decision which is subject to judicial review. But it's also in that context, and this is where I return to something I mentioned at the outset, where in our respectful submission, the interplay with paragraph 16 and 21 of Schedule 2 of the 1971 Act is important. Because while, of course, the powers under those provisions are triggered by reasonable grounds for considering or for suspecting that a person is subject to removal directions, if my learned friend were right, every appeal against a Section 82(2)(h) decision would effectively deprive the Secretary of State of the ability to form the reasonable grounds for suspecting that a person can be subjected to removal directions, because he has been told by the tribunal that he can't make removal directions. And therefore it would disable the Secretary of State from exercising his power both to detain and or to grant temporary admission. And in our respectful submission, that is wholly contrary to the purpose of those provisions as understood by the House of Lords in Kadir, which is at volume 4, tab 37. And in particular, paragraph 18, and then paragraphs 31 and 32. And your Lordships and your Ladyship will see in paragraph 18, Lord Brown, who gave the main speech in the House of Lords in this case, setting out the question whether the appellant, as at 3rd May 2002, the date of the decision under challenge, could be temporarily admitted under paragraph 21. That in turn depends on whether he was a person liable to detention under paragraph 16. There can be no dispute but that he was an illegal entrant who had not been given leave to enter, and was accordingly someone in respect to whom directions may be given under paragraphs 9 and 10 within the meaning of section 16(2). And of course, as I should have perhaps indicated at the outset, this case concerns the return of a Kurdish, an Iraqi national of Kurdish origin, and the inability to remove him, there being no scheduled flights to the autonomous region and no other means by which such a person could be removed. So it was very much a case concerned with the impact of practical impossibility or difficulties in relation to removal and its impact on the power to grant temporary admission. And there we have Lord Brown, with whom the other members of the court agreed, setting out his conclusion on paragraph 16, and then at paragraph 31 and 32, and in particular 32, in 31 he endorses a decision of my Lord Justice Lord Mans, was right to recognise a distinction between the circumstances in which a person is potentially liable to detention and can properly be temporarily admitted, and the circumstances in which the power to detain can in any particular case properly be exercised. And then in 32 concludes, the true position in my judgment is this: pending in paragraph 16 means no more than until. The word is being used as a preposition, not as an adjective. Paragraph 16 does not say that the removal must be pending, still less that it must be impending, so long as the Secretary of State remains intent upon removing the person, and there is some prospect of achieving this. Paragraph 16 authorises detention meanwhile. Plainly, it may become unreasonable actually to detain the person pending the long-delayed removal, i.e. throughout the whole period until removal is finally achieved, but that does not mean that the power has lapsed. He remains liable to detention, and the ameliorating possibility of his temporary admission in lieu of detention arises under paragraph 21. And the only other substantive, though somewhat shorter speech, was given by my Lady Baroness Hale, agreeing with Lord Brown at page 211, paragraph 4.
Well, I agreed with paragraph 32, basically, didn't I?
My Lady, yes, Your Ladyship did. It's just above E. Under Schedule 2 of the Immigration Act, there's power to detain pending removal. Pending in this context means no more than until. And of course, this points up another difficulty my learned friend has in my respectful submission. Having accepted, as I understood him yesterday, that a successful appeal, even on his ground, cannot automatically lead to a grant of leave to enter or remain, but at best will, as he put it, tilt in his favour in the Secretary of State's consideration of his circumstances, it is difficult to see how, on my learned friend's construction, he can be not granted leave and therefore be retained on temporary admission. While, of course, if the tribunal were to allow the appeal on his basis, the Secretary of State would, in effect, be deprived of his ability to detain while he was still intent on removing a person from the United Kingdom, and until that person had been removed. That approach was further confirmed in the decision of the Court of Appeal in MSAR and FW, which is also at volume 4, tab 50. Where Lord Justice Sedley identifies the issue at paragraph 2, and then sets out his conclusions at 26 and 27, where he makes the point that foreign law is in legal principle a matter of fact. It's also the case that the obstacles to return are commonly an amalgam of fact, governmental practice and policy, international law and local law, often in a form which is impossible to disentangle. The present case illustrates this. I would hold that any difficulty, whatever its nature or origin, which has the effect of impeding return, is a practical difficulty within the meaning of paragraph 67(2)b. Perhaps this is a convenient place to look at section 67, which the court will find at paragraph 4 of Lord Justice Sedley's judgment. Section 67 of the 2002 Act, which is of course the very Act we are concerned with, and which sets out that in 1 it says this section applies to the construction of a provision which does not confer power to detain a person, but refers in any terms to a person who is liable to detention under a provision of the Immigration Act, which is plainly a reference to paragraph 21 of Schedule 2 of the Act, as the House of Lords and Kadir recognised. And in 2, Parliament then makes it very clear that the reference shall be taken to include a person if the only reason why he cannot be detained under the provision is that B, practical difficulties are impeding or delaying the making of arrangements for his removal from the United Kingdom. And again, in my respectful submission, it is difficult to see how that provision and that clear expression of Parliament's intent that somebody can be retained on temporary admission, even though there are practical difficulties impeding or delaying the making of arrangements for his removal, that person can be retained on temporary admission, how that can be effective if my learned friend's construction of the word immigration decision under 82(2)h is right, because of course as soon as a tribunal were to find on an appeal against that decision that there are practical obstacles and therefore the appeal is allowed, deprive the Secretary of State of the basis for detention under paragraph 16, and therefore of his power to grant temporary admission under paragraph 21. Finally, in relation to these provisions, even if we were wrong, it appears that my learned friend now accepts that the test is the very low test which my Lord Mance put to him, namely that there are reasons to believe that the Secretary of State will, at some point in the future, have reasons to believe that he will be admitted. And in our respectful submissions, even on the facts of this case, and leaving aside the application for further evidence and the like, in my respectful submission, there is no basis on which this could be, on which this case could concede applying that test. And if I can just give your lordships and your ladyship some references, that is that the case in MA Palestine, which my learned friend referred to, volume 6, 68, paragraphs 26, 27 and 61, which record that there was no evidence before the tribunal that it was possible, but there was plainly no evidence that it was impossible to remove, something which the Court of Appeal confirmed in AK, volume 3, tab 26, where the AIT concluded that the return was possible, and the Court of Appeal at paragraphs 34 to 41 upheld that finding. Can I then just make, I hope, two relatively short further submissions before sitting down. The first is that in our respectful submission, the Secretary of State's construction is also supported by the mere wording of section 84 of the Act, which, and in that it is in our respectful submission important that paragraphs A through to E make reference to the fact that the decision is not in accordance with the law. And of course that decision does not include removal directions. And that in E, having listed number of express bases on which it is not in accordance with the law, such as in A, the immigration rules, in B, the Race Relations Act, in C, the Human Rights Act, and in D, community treaties, it then says that the decision is otherwise not in accordance with the law. And one can see how that would encompass public law grounds in relation to the in principle decision. For example, where there is a failure to comply with legitimate expectation arising out of a policy.
Your 20, what was it, 15 or 20-year case?
For example, the 14-year case,
14.
Or other policies in relation to family life or the like. And in that, even in a case recently where the Secretary of State made the decision in reliance of an ultra-virus statutory instrument. But that related to what we say is the in-principle decision. And we say that's supported by the fact of A, the use of the word is, B, the use of the word otherwise, and C, the location of E. Because E is on purpose located before F and G, so it is not the catch-all my learned friend seeks to make it, which seeks to catch everything that doesn't fall into A through to G, but it is at best a catch-all of A through to D. And Parliament then was very careful in G to draw a very clear distinction and grant a right of appeal, or a ground of appeal, enable a ground of appeal to be raised in relation to something that would arise as a consequence of the immigration decision, and that is the removal. And there, Parliament again was very clear that that was defined very closely to two bases, namely the Refugee Convention and the Human Rights Act. If Parliament had wanted to achieve what my learned friend sought to achieve, in my respectful submission, they would either have included the words otherwise not in accordance with the law in G, which would have made, in my respectful submission, much more sense, that removal in consequence would not otherwise be in accordance with the law, or would have placed E, at the very least, placed E behind G in order to make it, and to make it clear that it was the catch-all my learned friend seeks to make it.
But it is a bit odd, isn't it, as a scheme, that in some circumstances, human rights considerations may require you to consider a future position relating to entry and the safety in particular of entry into a particular foreign country, whereas on your analysis one can't consider the feasibility of a future entry. I mean, wouldn't a lot of your arguments, namely that these things should be viewed at the time they arise, would suggest that a different scheme, a scheme according to which there was some specific right of appeal against, I suppose, removal directions on the grounds that they breached human rights. Instead, one has to do it by judicial review.
Well,
if you get over the hurdle of G, there's still a possibility that at some future date there will be, because of changing circumstances, a potential human rights breach in sending someone abroad.
My lord, that may arise, but in my respectful submission, it isn't as anomalous as it seems, because the exercise, in one sense, is a very different one. Considering whether removal of an individual will expose him to a real risk of treatment contrary to the Refugee Convention or the Human Rights Convention, is one that is done by reference to the evidence the individual gives about his personal circumstances and the objective evidence about the human rights situation and the activities of another state. The removal of the individual, of course, is not done by reference to that objective evidence. It requires actual contact between the UK and that state and the making of practical arrangements for his removal, which is something which, in my respectful submission, is a very different class of evidence. It's a very different class of administrative action that is being reviewed, and it is one that is not capable of being reviewed, if I can call it that, in the abstract, as the human rights risk is, which of course now the Court of Appeal has made clear includes the route of travel and the treatment he will receive at the border.
I mean, can it really be dealt with in the abstract, actually? Because supposing the question was one of someone's safety because he had particular enemies, then the first thing that might be done is try and get assurances that he be given particular protection. And that takes you from the objective to the subjective straight away, so that under G one might well find oneself litigating quite specific issues.
My Lord, I'm in relation to the grounds under G, for example, the type of assurances your Lordship is talking about in relation to the specific individual would not be in place, because of course they would only be made once removal was actually put in train. But for example, of course, it would be open to consider whether a memorandum of understanding, as we know from the Sire cases, RB and U and the House of Lords and others, is whether that is in place and whether that is capable of being effective in relation to the objective circumstances, human rights circumstances in that country, and the circumstances of the individual as found by the tribunal.
I'm sorry.
But so what I was going to say, though, is but the actual removal, as we see in this case, is much more concerned with the nitty-gritty of, for example, how likely are you to get a travel document for this individual? Are you going to get a seat on the flight BA251 rather than a flight 3 days later? And removal directions of that sort frequently need to be revoked and remade because of the very practical nature of the issues at stake, rather than the more broad issues. Is he going to be at risk of being treated contrary to his human rights?
Like all of those which contemplated removal during the recent problems in the air.
My lady, yes.
All have had to have been revoked and remade, supposing that there were any.
My lady, yes.
There might have been a few.
I think it was long enough that there's likely to have been some.
Even those behind you laughed at that.
What would the position be if the immigration decision is taken, and let us say that there is an appeal on human rights grounds which is rejected. Some months go by and removal directions are given, and at that point the person to be removed says, well, actually the circumstances in the country to which it is proposed that I should be removed have changed, and in the light of those new circumstances I wish to assert a human rights objection to my removal. How does that work?
Well, my Lord, there are, in a sense, there are two avenues. One is the individual could make fresh representations, and there's then a question under the immigration rules whether the Secretary of State will consider them as a fresh claim and deal with them as such or not, and a refusal to treat them as a fresh claim may be subject to judicial review, or the decision to remove would be subject to judicial review on the basis that the Secretary of State has failed to comply with his obligation under Section 6 of the Human Rights Act to act compatibly with an individual's human rights. And of course the High Court is as the last 12 years have shown, is now well equipped, even if it needs fact-finding, to deal with those kind of human rights cases. But actually, in reality, while there are numerous challenges to the failure of the Secretary of State or the refusal of the Secretary of State to deal with such a claim as a fresh claim, and they, I understand, are the first group of cases where JR is being transferred to the upper tribunal, it is, in terms of actual removal directions, the case of Yassin, which is in your Lordship's papers, is the only judicial review we're aware of, certainly reported case, of those challenges. And we understand, certainly my instructions are, that those kind of challenges are very rare. Challenges.
It's the only judicial review case in respect to removal instructions.
Of removal directions themselves, in that whether the individual will be accepted in another country is the judgment of Mr. Justice Sheeman and Yassin.
Yes.
And that was a nitty-gritty case, I think, wasn't it, to use your phrase?
Well,
it was a judicial review based upon a nitty-gritty point rather than convention points.
Well, that's what it was ultimately decided on. It was two Lebanese nationals, I think, who came to the United Kingdom on a Brazilian visitor's visa. They were in transit in the UK, and they got the visitor's visa by fraud. And the question was whether they arrived in the UK in transit, made an asylum application, and the Secretary of State refused to consider the application and said, you should make that application in Brazil and set removal directions for Brazil. And the question was whether paragraph 8 requires that the Secretary of State should be satisfied that they should be admitted, which of course plainly they should have been under the Refugee Convention, or whether they would be admitted. And he decided that on the material before him, no country that was told that the visitor's visa had been obtained by fraud, or certainly Brazil in those circumstances, would not admit them, and quashed the decision on that basis.
Can I just ask a different question? Where do you get the obvious conclusion that if an appeal is allowed under Section 82, then it's impossible to give removal directions? Because the provisions for removal directions predate and don't predate the 2002 Act and don't refer to an immigration decision. Therefore, the 2002 Act sort of interposes that as a requirement. Perhaps I think it was in the original legislation in different terms there.
Well, my Lord, if my learned friend is right, his appeal would be against a decision which includes the country, which under 82(2)H, which the tribunal would then allow, and therefore that decision was quashed. Yeah. And therefore, if my learned friend is right, there are no removal directions to be set to that country, because the tribunal has told the Secretary of State that he can't set removal to that, unless circumstances change significantly.
The answer is that the immigration decision is treated as a further step, not expressly referred to in Schedule 2, which only refers to someone not having leave to enter or remain.
My Lord, yes, but of course it's accepted that on a judicial review against the removal directions, the country to which a person is set may well be the subject of consideration. But if the tribunal has found that that country is not available, if I can put it like that, then of course that power falls away.
Okay. What if? I mean, you're right. Let's assume that you're right. Then the immigration decision simply relates to the abstract decision to remove from the UK, and the directions, the proposed country is not part of the essence. So you can actually think about giving removal directions in respect of a different country. Can you?
My Lord, if, and this happens not infrequently, as the case of KF shows, in cases of mistaken or disputed nationality, where an individual says, I'm Somali, and the Secretary of State says, I don't believe you're Somali, I think you're Kenyan.
Yeah.
But because, giving you the benefit of the doubt, the proposed destination is Somalia.
Or you set an alternative under the new...
Well, there is then the power to set an alternative, but even where that is not done, the requirement is that the Secretary of State, if that were the case, and the tribunal were to find, yes, Secretary of State, you are right, and it is Kenya, to then make a new 82.2h decision proposing Kenya as the country of removal to enable the tribunal to deal with the 84.1g ground of appeal.
If there is an 84.1g, if there isn't, presumably you don't even need to go through the hoop of having a new immigration decision, because there's nothing to appeal.
My Lord, yes, even though that will be a very rare scenario, because of course the disputed nationality cases and others are usually those which have by that stage raised the human rights issue and have expressed a fear of treatment on return, certainly to one country, and therefore it will be part of the analysis as to whether there is that fear exists and prevents removal to another.
So even though it's not part of the decision, the destination, what you accept the approach, I think, stated in AF and in MA, sorry, KF and MA, that in practice the right thing for the Secretary of State to do if he changes the proposed destination is to produce another immigration decision.
Yes, my Lord.
But logically, you wouldn't have to do that.
My Lady, logically, there is no requirement to do that.
The
But it would
principle would enable you to make whatever directions.
My Lady, yes. But what it would do is would deprive the tribunal of the ability to consider 84.1g in relation to the proposal that is proposed as a result of the decision.
I mean, I appreciate that it's a very fair thing to do,
Well, yes.
but it doesn't seem to be logically required by the statutory scheme.
No, and
if you are right on your principal argument.
My Lady, no, there's no requirement in the original in the legislation that imposes that as a requirement, but that is the practice in order to give effect to Parliament's view that the tribunal should be able to review the consequences of removal in light of the Human Rights Convention and the Refugee Convention.
I suppose there's nothing to require the Secretary of State to stand by an immigration decision. If he happens to have made it, he can say, I'm going to treat that one as irrelevant, I'm going to make another one.
My Lord, I'm not sure I understand.
Well, I mean, that's what he's doing in this situation. He's saying, as my lady points out, logically, the immigration decision on your case is valid even if the destination proposed is changed. And therefore, even if there are human rights questions, logically, they would have to be determined by way of judicial review of the removal directions. But in practice, there's nothing to stop the Secretary of State saying, sorry, I'm going to abandon my previous immigration decision. Out of fairness, I'm going to issue a fresh one, which will give the right of appeal in respect to...
I mean, and that's what is routinely done.
Yeah.
That's what happens as a matter of practice.
And I have just read a paragraph in one of the decisions which suggests that that basically should be done.
KF.
It's KF, is it?
KF made quite clear that Mr. Justice Ousley took the view that that was a legal requirement. There, the Secretary of State said, we do this as a matter of practice.
Yeah.
KF then led to the enabling provision, and of course the paragraph in paragraph 5, or regulation 5 of the notices regulation says may name more than one country. That was inserted, and following KF, that is always done, that a second decision is made.
Yes, and the cases, you touched on it a moment ago, the cases show that there are situations where the Secretary of State really can only propose a destination which he then, in fact, intends to challenge in the course of the proceedings as an appropriate destination, because the only information he has is information coming from the applicant.
My Lord,
And
yes.
you say that's a perfect. I mean, it's a slightly strained use of the word proposed if the Secretary of State actually proposes to challenge the genuineness of the applicant's stated country of origin.
My Lord, yes, and that I wouldn't put it quite the way your Lordship put it to me, in the fact that he's challenging the destination. What the Secretary of State is challenging is the individual's underlying claim as to nationality, which goes to persecution, because of course, unlike the human rights claim, the Refugee Convention hangs on persecution in the country of nationality, where there is a nationality. And therefore it is a core element of the asylum analysis, country of nationality. And the Secretary of State may well challenge the evidence of the individual that he is a national of a particular country. But giving that individual the benefit of the doubt, if one can call it that, using the proposed destination that is required to be put in, he says, if you are right, that is where I intend to remove you, because I have analysed your asylum claim solely by reference to your evidence, namely on the hypothesis that you are Somali, even if ultimately I don't think you're credible and I don't think you are Somali. But that's the only thing I can analyse your claim against, and that's what I've done. And if you were right on your nationality and I'm right on my assessment of the human rights situation, then that's where I propose to remove you.
Yes, but I mean, the reality is the Secretary of State in that situation actually proposes to remove the applicant to some unknown country which he has yet to work out.
My Lord, yes, but of course, as the tribunals and the court have noted, to leave it at that, and that's what paragraph 5 or regulation 5 of the notices of regulation seeks to deal with, that would leave the tribunal in a very unsatisfactory position of not being able to identify the country against which the human rights and the refugee claim potentially are to be assessed.
Presumably what happens now, I mean, one of the cases, I forget which, is about a woman of Somali origin, but who had obviously, the Secretary of State, not been living in Somalia, must have been living in Kenya. And so in that situation, I suppose nowadays the Secretary of State would say, I propose to remove you to Somalia or alternatively to Kenya.
Well, I think the case was MA, and as much as in an ideal world that may well be what ought to happen, I think in that case it didn't happen, and it was a question of making a second decision.
Yes.
Afterwards.
Yes, that's right. But I mean,
but yes, I mean the possibility now is there that the Secretary of State could say, because I don't believe you're from Somalia, I propose to be the two countries against which I want the AIT to, or now the upper tribunal or the tribunal to look at removal under 84(1)(g are Somalia and Kenya. That would be possible. That power is now available.
I mean, it isn't really so much a matter of fairness to the person to be removed to produce a second decision. I would have thought that it was in the interest of the Secretary of State to do that, because the Secretary of State, as you make absolutely clear in your case, the Secretary of State wants to have these crucial fundamental questions resolved at as an earlier stage as possible, and not resolved at the last moment when, by judicial review, when the removal directions come to be given.
Well, yes.
Because if you get to that stage and then there's a judicial review, there's a huge hold-up.
Well, yes.
And circumstances can change yet again by the time the judicial review outcome is known.
My Lord, yes, that's certainly right. And it goes with something my learned friend relies on heavily, the one-stop approach, namely that all the important issues are determined by the tribunal, because even if there is then a subsequent judicial review, the detailed finding of the tribunal will, of course, give a basis for consideration of that change of circumstances, both by the Secretary of State and the court, if that's where it should go. But yes, no, I fully accept.
But on your approach, there should only rarely be any need for judicial review.
My Lord, yes.
Because if you're right, and at that stage you're dealing with the mechanics, strictly so-called, then the Secretary of State has every reason to make sure that the mechanics are in place before he makes his removal directions. Otherwise, he's going to be faced with a judicial review.
My Lord, yes. Then I made reference to the Court of Appeal cases in relation to, which have now made clear, culminating in the case of AK, making clear that the tribunal can, of course, under 84.1g, consider whether there is a risk of a breach of human rights or the Refugee Convention, even en route, i.e. by the route or mechanisms that is being used to return. But what the courts have also made clear, in my respectful submission, is that that is delimited by 84.1g and does not include obstacles arising out of other practical obstacles or technicalities, as it may be called. And in our respectful submission, that is supported and not undermined by the decision my learned friend took you to, handed down on Friday, in HH Somalia, because if I could ask your lordships to, and your ladyship to turn that up briefly, you were taken to some of the passages, but if I could ask your lordships and your ladyship to turn to paragraph 71 and then 80 to 83, and I hope there was at one point a discrepancy between paragraph numbering. 71 in my copy starts with the reason it is submitted is that
72.
72, so I am one out, my lord. I will try and stick with it. So 72 just records the obvious, that it's the obligation of the national courts to read our domestic legislation conformably with the two European directives which now deal with asylum and humanitarian protection, both of which are in volume 2, but then in what would be then 81 to 84, I hope, set out their conclusions by reference to the two directives, and note that 3 lines down in 80, that they do not consider that the fact that an appeal from removal directions is by way of judicial review rather than statutory appeal is of itself an insuperable objection, but we do think that in the case in which the applicant raises a cogent argument within his statutory appeal, it may not be a safe route. The Secretary of State must address that question, and the issue must be considered as part of the decision on entitlement.
Sorry, where are you?
Sorry, this is 81, I hope, my 80, and I think your ladyship's 81, starting, it appears to us.
Yes.
But it then goes on in the court's paragraph 82 to make clear that this, under the Qualification Directive, excludes technical obstacle to return from the determination of entitlement, which gives 3 lines up from the bottom in mind, or 7 lines down from the beginning of the paragraph, gives some modest support to the suggestion by counsel from the Secretary of State of the mechanics of the return not being intended to form a part of the case for protection. But not much for support, for it starts with the words as part of the assessment, the application for international protection. Nevertheless, its first paragraph treats the availability of internal relocation as a factor negating any need for protection, and its third paragraph excludes from this calculation any technical obstacles to return. Then in 83, there remains a question, this is 3 line in, about what constitutes technical obstacles to return. In our view, these are probably confined to administrative difficulties such as documentation. They may include physical difficulties such as the lack of return flights. The phrase does not readily signify a requirement to ignore risk to life or limb once the returnee is back in the country of origin, not only because it does not say so, but because to do so would be to permit the very thing that the directive is designed to prevent. Our view is that the mere fact that technical obstacles are excluded from consideration suggests that issues of safety during return are to be considered. So, in our respectful submission, that supports the submission the Secretary of State makes, namely that technical difficulties or technical obstacles, as the directive puts it, such as, in this case, the availability of documentation or the availability of flights, are not part of the decision under appeal, but fall to be considered under the fall to be considered by way of judicial review in relation to the actual removal directions.
Safety seems to have a fairly technical sense in this context, doesn't it?
My lady, safety in this context, in my respect, refers to safety in the human rights, in the
Exactly.
Article 3.
In either the non-persecution or non-human rights violation sense.
My lady, yes. It's that safety, and going slightly beyond that in the Qualification Directive, anything that would entitle to subsidiary protection or humanitarian protection under the directive, it's that type of safety which is concerned, rather than a broader meaning of safety, my lady, yes.
Are the trains safe? Yes.
My lady, yes. That deals with what I was going to say in relation to section 84. Can I then just finally, I hope, make the following submissions on the basis of section 120. In our respectful submission, again, the language of 120 supports the reading of the interpretation suggested by the Secretary of State in relation to section 82(2)h, because the language of the section itself makes clear that it focuses on section 122b on permission to enter or remain in the United Kingdom, and c, any grounds on which he should not be removed from or required to leave the United Kingdom. Again, it does not make any reference to destination at all, and of course the appellant now accepts that even if he were successful on his ground, if it exists, a successful appeal could not lead to permission to enter or remain in the technical sense, but would at best tilt in his favour, as he put it. The second aspect of the language of section 120, which in our respectful submission supports that conclusion, is the use of the word grounds in subsection 2b and c, which both the explanatory report and the Court of Appeal, in my respectful submission, have made clear, suggests that the word ground refers to grounds available under section 84, and does not have a broader reach to cover other bases, other reasons, by reference to which removal may at the moment not be possible. The explanatory report the court has at volume 1 tab 9, and we looked at that briefly yesterday, at paragraphs 219 and 220.
Sorry, what was the reference?
So this is volume 1, tab 9. This is the explanatory report to the 2002 Act. And in our respectful submission, the crucial words in this context are 4 lines down in paragraph 291, where multiple decisions would result in multiple rights of appeal. These are subsumed into one appeal. All appeal grounds, or all appealable grounds of appeal, can be raised in that appeal. The requirement for a person to state all grounds for their applications, see section 120, helps to ensure that all relevant issues are dealt with in one appeal.
Sorry, where were we reading?
219.
Sorry, 219, my lord. I apologise. 219, 4 lines down, were multiple decisions. Could I also, while we have this volume up, just ask your lordship and your ladyship briefly to look at tab 11, which is the explanatory notes to the 2006 Immigration, Asylum and Nationality Act, which in section 48 made changes to the setup under section 10 of the 99 Act, which we looked at earlier, which are similar in effect, and draw the court's attention to the explanatory notes at paragraph 127, which sets out the background. Under the 1999 Act, the giving of removal directions under Section 10 could attract an in-country right of appeal if the person concerned was appealing under Section 65, the basis that removal would breach his human rights. Directions would often be given at an early stage in the removal process in order to trigger a right of appeal under Section 65. However, as removal directions often had to be cancelled and reset, this often gave rise to further rights of appeal against the giving of the second and subsequent set of removal directions. This was rectified by Section 82 of the 2002 Act, which provides of a right of appeal against the principal decision to remove by way of directions as opposed to subsidiary decisions to give removal directions. Section 48 makes correspondent amendment to Section 10.8 so that the invalidation of leave reverts to the point at which the person is notified of the appealable decision.
To what extent is the explanatory memorandum on a subsequent piece of legislation a legitimate aid to construction of the earlier piece of legislation?
My lady, I would only take it as far as it being a legitimate aid in the construction of Section 48, which of course seeks to build on the developments Parliament put in place in Section
Yes, and you
Section
don't want to
82.
go on to say that Section 48 would be nonsense without the previous.
My lady, I'm not sure I would go that far, but that's as far as I would take it. But that is the understanding on which Parliament has progressed since the 2002 Act.
But can we look at this, I don't know whether we can, as indicating part, at any rate, of the mischief at which the amendment, the 2002 amendment to getting rid of the right to appeal against removal directions.
My Lord, I would certainly suggest that the factual description of what happened in the past.
This seems to be going back to and talking about the position pre the 2002 Act.
My Lord, yes, it describes the situation as it was under the 99 Act, which of course the Court will recall was there was a right, a general right under human rights grounds, which led to the judgment in Karaharan, which then, it is now common ground, led to the change in the law, because it gave a right in relation to removal, right of appeal in relation to removal directions, where none was intended, which led, as this factual description, in my respectful submission, that is possible to have regard to, that factual description shows what happened, namely that because of technical reasons, like the cloud last week, removal directions were subject to an appeal, they had to be cancelled, and promptly a second right of appeal was triggered. And that, of course, in our respectful submission, would be exactly what would happen if my learned friends were right, and we would be back to where we were then.
Just remind me who prepares explanatory notes.
My Lord, as I understand them, they are prepared by the sponsoring department.
Yes,
They are not.
so this is just a reflection of the Secretary of State's current view.
My Lord,
Well, he's talking about the factual position as it was pre the 2002 Act.
that is, in one, on the factual front, is the Secretary of State explaining what happened, to explain why
That's
he's
what he
seeking
thinks
the change.
happened.
My Lord, being the Secretary of State concerned with the operation of this scheme, it is, may assume, he is best placed to say what happened in practice.
Well, I think there's a certain danger in
My Lord,
looking at material that's years after the event in the context of litigation where the very department is seeking to defend its stance.
My Lord, that may well be right, but that is the highest I can put it, that is as the factual situation was explained to Parliament when it passed the 2006 Act, and that is as far as I can put it. But it, in our respectful submission, accurately relates what happened leading up to the judgment in Karaharan and then the change in the 2002 Act. But in our respectful submission, that focus on the word ground is also reflected in the judgment in AS, which you were taken to yesterday, which is at volume 3, tab 27. This is where the first judgment is given by Lady Justice Arden, who, in the result, was in the minority. She sets out the competing arguments in relation to the one-stop notice at paragraph 1. The appellants say that the effect of a one-stop notice is that the appeal covers not only any ground before the Secretary of State when he made the decision under appeal, but also any grounds raised in response to a one-stop notice, even if they have not been the subject of any decision, does not relate to the decision under appeal. This is the wider interpretation. The Secretary of State contends that the one-stop notice have a far narrower effect on appeal. His case is that the only grounds can be put in issue on appeal are grounds placed before the Secretary of State when he made his decision, or grounds raised in answer to a one-stop notice. So even there, the premise was, those were the competing arguments. Lady Justice Arden gave her conclusion on that principal issue in paragraphs 47 and 50, where she considered that the grounds for accepting the narrower interpretations are stronger than those for accepting the wider interpretation. And in her judgment, the narrower interpretation represents a true interpretation of the obligation imposed by section 85.2. And then in 50, contrary to the appellant's submissions on the facts, the AIT was not, in my judgment, wrong to reject AS further submissions that the new grounds were sufficiently connected with those on which the Secretary of State had determined the application to fall within section 85. The ground raised in response to the one-stop notices was entirely separate from the grounds for leave to remain previously relied on. Application under the IGS was obviously different in substance from an application by AS to establish herself in business. Therefore, the AIT had no obligation to consider it. Similarly, in the case of NV, her additional grounds seeking leave to remain on the student basis was an entirely different basis from a previous application for leave to remain on the basis of 10 years residence in the United Kingdom. Now, in paragraphs 109 and 113, Lord Justice Sullivan considers this issue again for the majority, as one of the two members of the majority, and in 113 it sets out his conclusion. The 2002 Act defines those decisions in respect to which an appeal may be made to the AIT and the grounds on which such an appeal may be brought in sections 82 and 83 respectively. It is readily understandable that the AIT should not be required to consider a matter raised in a statement of additional grounds if it does not constitute one of the grounds on which an appeal may be brought under section 83, or if it seeks to challenge either a different category of immigration decision as defined in subsection 82.2 to that which has been taken, e.g. refusal to vary leave where entry clearance has been refused, or some other decision against which there is no right of appeal under section 82. And
is
in our
83
respect,
a slip for 84 there?
But, so, my lady.
Is 83 a slip for 84?
My lady,
Must be.
Yes, because 83 gives a different right of appeal.
83 gives you,
narrow
that must be
class
my, that must be my lady, yes.
So 83 must be a slip.
My lady, yes.
I find it a bit difficult to see to ascertain what the factual course of events here was. There actually been a notice of decision under section 82, haven't there?
My lord, yes.
And then a section 121 notice was served, and then some further grounds were given relying on different points.
My lord, I think the facts are briefly summarised in the judgment of Lady Justice Arden at paragraphs 6 to 9. And of course, this isn't an illegal entry case, so the documents the court would be looking for would not be IS 151, but there, in AS's case,
yes, that's right.
She came as a student, was granted further leave, obtained a degree. Before the expiry of her leave, she submitted an application for leave to remain as a business person, so different from the student. That application was refused, and a one-stop notice was included. But she then subsequently submitted an application for leave to remain under the International Graduate Scheme, and she lodged a notice of appeal against the decision of the Secretary of State. And then...
and the argument was about whether the tribunal could deal with...
the IGS application,
yes,
as well as the
initial one.
As well as the initial one. And both Lady Justice Arden in the minority and Lord Justice Sullivan in the for the majority concluded that they were not required to look at what would be a different decision or a different ground of appeal under 84.
They were not required to. they took a wider view of what you could look at. So
My Lord, as I read Lord Justice Sullivan at 113, he seemed to accept as readily understandable why the AIT should not be required to look at matters which do not constitute one of the grounds of appeal made under Section 84.
well, yeah, but it didn't have to include one of the original matters considered by the Secretary of State when he made his Section 82 decision.
No.
So you can bring in after a 120 notice all sorts of matters which actually haven't been considered by the Secretary of State, and the only person who considers them is then the tribunal. Yes,
My Lord, yes, but
no,
I was relying on this in order to support my emphasis on the word ground in 80 Section 120, and that being limited to permissible grounds under Section 84, which
yes.
of course only include the ground that removal in consequence of the decision is contrary to human rights or the Refugee Convention, yes. Which of course is not an issue here.
So, on that, the court is here in agreement.
Yeah.
Yeah. So that.
Yes, my Lord. That's how I read.
Yes, I see it.
My Lord, my Lady, if you could just bear with me 1 second. My Lords, my Lady, unless there's anything else I can assist the court with, those are, in addition to the printed case, those are the submissions on behalf of the Secretary of State.
Thank you very much indeed.
I'm grateful.
May it please your Lordships and my Lady, the first point that I would like to address by way of reply relates to the proper approach to the significance of the notices regulations. And I wondered if I could draw attention, first of all, to the authority of Hanlon versus the Law Society that was referred to by the court yesterday. We made some copies of it and would like to hand it up. The passage, I think, that was drawn attention to was at page 193, capital G, to 194, capital C. And if I may draw attention to the first proposition, subordinate legislation may be used in order to construe the Parent Act, but only where ... the meaning of the Act is ambiguous. And then proposition number 4, where the Act provides a framework built on by contemporaneously prepared regulations, the latter may be a reliable guide to the meaning of the former. And these propositions, in the context of this case, perhaps give rise to 3 questions. Whether the 2003 regulations made contemporaneously with the 2002 Act. Is Section 82(2)H ambiguous about what must be included in the immigration decision? And is it a framework in the sense of being an enactment that doesn't exhaustively prescribe what the decision must include? Now, addressing the first point first, as was with respect correctly pointed out yesterday, the 2003 regulations were made on the 11th of March 2003, which is some months after the 2002 Act was enacted. But Lord Lowry is careful to refer not to the date when, or the time when regulations were made, but when they were prepared. And almost inevitably, in my respectful submission, although the 2003 regulations were made some months after the 2002 Act, they must have been prepared contemporaneously with that Act in the sense of around the same time. But if there is any gap, that gap can be readily bridged in a way that's highly relevant to the way one looks at the questions raised by propositions 1 and 4, because the 2003 regulations didn't come out of the blue. They were the last, they are the most recent of a series of regulations which are all in broadly the same sort of form, and they're in the bundle in volume 2. We've been looking at the 2003 regulations behind tab 18. Behind tab 16, one finds the predecessor, behind tab 14, we have the predecessor notices regulations, which at regulation 5 provides that a notice must include a statement of reasons and include a statement of the country of removal. And then before that, behind tab 13, we had the right at the bottom of the first page, the 1984 notices regulations, which at regulation 4, the last page, 617 at the top, again contains similar requirements as to what a notice must contain. In other words, reasons and a specification of the country or territory of destination.
There is a significant difference, isn't there, between Regulation 5.1b in the predecessor regulation and Regulation 5.1b in the new regulation. The predecessor regulations say if it relates to the giving of directions for the removal of the person from the United Kingdom. That is, of course, because no such appeal any longer exists.
The notice under Regulation 4 is a written notice. Your Ladyship is looking at the 2000 regulations. The notice under Regulation 4 is a written notice of any decision or action taken in respect of him which is appealable.
Well, that's the point. Previously, as I understand it, was possible to appeal against the removal directions.
Previously, there were some very limited appeal rights against removal directions. That is correct.
So there's an express reference to a notice, which obviously relates to a decision which is appealable, relating to the giving of directions for the removal, whereas the current version of Regulation 5 is, not surprisingly, differently worded, because the range of appealable decisions is different. Possibly. It may not take us very much further, but it's...
I'm not able to provide a comprehensive answer to that. I think the way that we had read that, the way that we had read regulations 4 and 5 in the 2000 regulations was to require a notice including a statement of the country of removal wherever a decision was made under Regulation 4 that related to the giving of directions for removal, and we had read that as embracing a wider category of decisions than simply removal directions themselves.
It doesn't really matter which is right, does it?
Your Ladyship may well be right, but the more limited point that I seek to make from that is that at the time the 2002 Act was drafted, the draftsman would have known that under the existing established requirements that applied to immigration decisions was included a requirement to state the country of destination in the immigration decision, in the appealable immigration decision, whatever that was, whether it was a notice relating to removal or the removal directions themselves. And the three submissions I make on that basis are that, one, if there is a gap in time between the preparation of the 2003 notices regulations and the enactment of the 2002 Act, that gap is filled by the existence of the 2000 regulations. And secondly, that in the context of there being an established set of requirements for what has to be included in notices regulations, one ought to read section 82(2)H as comprising a framework in the sense of not exhaustively prescribing what a decision must include, and as operating on the basis of there being established requirements for immigration decisions, including the specification of the country of removal. So, in combination, 82(2)H and the regulations provide that the immigration decision is a decision to remove to a specified country or territory.
Well, again, there's a difference between what Regulation 5 says in the 2000 regulations. It says, if it relates to the giving of directions for the removal of the person from the United Kingdom, include a statement of the country to which he is to be removed.
Yes.
Whereas the current regulations say, shall state the country or territory to which it is proposed to remove the person.
Yes, that is absolutely right. But the difference in language, in my respectful submission, is not significant. In the sense that what one is looking at is what comprises part of the appealable immigration decision. Whether it is the country to which the person is to be removed or the country to which it is proposed he is to be removed, nonetheless, it must all be part of the immigration decision. The second point in reply addresses both something put to me yesterday by the court and also the submissions made by my learned friend about the potentially difficult practical consequences of allowing an appeal against a decision under section 82(2)H to canvass difficulties in returning an individual to a particular country. Now, one of the things I was asked yesterday is, what is it about the language of paragraphs 8 to 10 that shows that the decision referred to in 82(2)H is more than a decision in principle? And our point really doesn't turn on the detail of the language in Schedule 2. Our point is that paragraphs 8 to 10 set out a limited series of different types of removal directions that can be made. And we say that logically, the only decision, therefore, that paragraphs 8 to 10 require is a decision to give one of those permitted types of removal directions. There's just no basis in paragraphs 8 to 10 for supposing that the decision-making process is any more complex or remote than that. It's simply the simple, straightforward decision that, as a matter of logic, always must directly precede the taking of the action. It's common ground in this case that MS can only be removed under paragraph 8.1c, so the only decision required by Schedule 2 is a decision to remove MS from the UK by using some carrier or other to an 8.1c qualifying country. And all that 82.2h does is provide a pause, a right of appeal, before, or a potential pause, in the form of a right of appeal before removal directions are actually given. If there's no appeal and no voluntary departure, removal directions should be given straight away. That's what the statutory scheme intends and requires. Now, the answer to the inconvenience point by the Secretary of State, firstly, I mean, obviously, administrative inconvenience can't change the meaning of legislation, and clearly that's not what my learned friend can have been driving at. More importantly, the sort of practical difficulties that he was drawing attention to is somebody going to be able to get a flight or a particular flight to a country, to a particular carrier. Those are not the sort of practical issues that need to be addressed in a paragraph 8.1c case at all. The issues under paragraph 8.1c are extremely simple. One turns back to page 39, tab 1, volume 1. The first set of inquiries, 8c, Roman numeral little 1 to little 3, are manifestly simple and straightforward inquiries for the Secretary of State to make and ought to pose no difficulty at all. Little 4 is the big, potentially the big question. But all that the Secretary of State needs to establish where the case turns on Roman numeral little 4 is that he has a reasonable belief that the person will be admitted to the country of proposed destination. And that will readily, that level of belief will readily be established in all cases, except where there is a clear and fundamental obstacle to admission, whether that is legal or practical. And in this particular case, the evidence on behalf of MS would be that for practical reasons, it was impossible, quote unquote, that he would be admitted to Palestine. And it's important also not to lose sight of the fact that whilst the decision is initially for the Secretary of State to make, the appeal is on both fact and law. So one isn't confined, as the tribunal, to reviewing the bona fides of the Secretary of State's view about this. The tribunal will examine the factual basis of the decision for itself under Section 85 of the 2002 Act before deciding whether or not the decision is in accordance with the law. So the tribunal ultimately will decide whether there is any reason to believe, any rational reason to believe on the evidence that, to paraphrase, removal directions can be made in the future in the particular case before it. That threshold is so low that there is no need for the Secretary of State to establish that he will be able to make practical arrangements in any but the most exceptional case where there is, as I say, some fundamental problem. And of course, the logic of the scheme is that if there is no appeal, or no voluntary departure, removal is expected to take place straight away. And the logic of the scheme, in my respectful submission, is that if removal is fundamentally impossible for a legal or practical reason, then consideration does need to be given to a grant of leave to remain. Thirdly, and directly in reply to submission made on behalf of the Secretary of State by Malone Friend, we don't accept that the consequences of our approach would be, in every case, to undermine the ability of the Secretary of State to detain or grant temporary admission. If one goes back to the second case that Malone Friend referred to, the case of MS in volume 4 behind tab 50. At paragraph 4, Lord Justice Sedley sets out the text of section 67 of the 2002 Act. Section 67, subsection 2, directly authorises the continued placement of an individual under temporary admission where either A, B or C apply. So notwithstanding a successful appeal, where section 67(2)A, B or C apply, there will be at least the power to continue to maintain a placement on temporary admission. Whether that power should be exercised or whether the Secretary of State ought to grant leave to remain will be a matter for him to decide in the light of all the circumstances of the case. But what the Secretary of State would find very difficult to do after a successful appeal would be to detain a person under paragraph 16 if the effect of the appeal was that he could no longer reasonably believe that removal under paragraphs 8 to 10 was lawful. But that consequence is consistent with the enactment of section 67, where there are serious obstacles in the way of removal. Parliament has expressly provided for the maintenance of a placement on temporary admission, but not further detention. And the rationale and the logic of that, in my respectful submission, is obvious, that it would be wrong to detain somebody simply because there was no immediate or even long-term prospect of their removal for these reasons. Next, my learned friend drew attention to at the outset of his submissions, to the discretionary nature of the decision under paragraphs 8 to 10, that removal directions are to be given. But that, in a sense, really draws attention to one of the stronger aspects of our case, if I may so submit, that really a consideration of the destination of removal logically is part and parcel of the decision that a person is to be removed. And if one looks at the guidance that my learned friend referred the court to on a number of occasions, one sees that spelt out in the guidance. It's volume 7, and it's tab 76. if I can ask the court to turn 4 pages in. The page on the right-hand side should start 53.1, illegal entrance and persons subject to administrative removal action under Section 10 of the 1999 Act.
So did you say tab 76?
Yes, I did. It's Authorities Volume 7,
Yeah.
tab 76. It's 4 pages in. On the right-hand side, the court should have 53.1 illegal entrance, that's us, and various other people. And what it says is full account must be taken of all relevant circumstances before a decision to remove is taken on a case. The factors to be considered are the same as those outlined in paragraph 395C of the immigration rules. And then again, under 53.1.1, before a decision to remove is taken on a case, the case owner, operational staff, must consider all known relevant factors. And in my respectful submission, the exhortation to consider all relevant circumstances and factors plainly embraces, just at this stage, whether or not it would be appropriate to remove an individual to a particular country. And that is then underlined to some extent, at least, when one looks under the heading 53.1.2 at the very bottom of that page at what some of the identified specifically relevant factors are. Under age, over the next page, an unaccompanied child under the age of 18 wouldn't normally be considered for removal unless there's evidence that satisfactory reception arrangements are in place in their home. And then across the page, at the bottom of that page, there's a heading, residence accrued as a result of delay by UK Borders Agency. Then the second paragraph over the page, in addition to the foregoing, provided that none of the factors outlined in personal history weigh against the individual, case owners should also place weight on significant delay in cases where, for example, then the second bullet point, family cases where delay by UKBA has contributed to a significant period of residence. For the purposes of this guidance, family cases means parent as defined in the immigration rules and children who are emotionally and financially dependent on the parent, etc. Following an individual assessment of the prospect of enforcing removal and where other relevant factors apply, a 3-year period of residence may be considered significant. And then the next bullet point, again, any other case where delay by UKBA has contributed to a significant period of residence following an individual assessment of the prospect of enforcing removal, a grant of 4 to 6 years may be considered significant. So both some of the specific factors and the overall requirement to consider all the circumstances of the case draw attention to the fact that the discretion, or the proposition, I should say, that the discretion whether or not to issue removal directions will, of course, as a matter of ordinary logic, have to consider the country of destination, whether it's appropriate to remove to that particular country, and whether it is possible to do so.
It seems to me, or rather on the contrary, remarkably lacking in any reference to those factors which the experience of the courts, which is not, of course, representative, might lead one to suggest were rather important, particularly in the area of human rights claims. But I mean, anyway, you say it's embraced, but it's not very specific, and there's nothing which says, of course, you must consider whether there'll be any human rights problem back home. So, as it doesn't deal with that, it seems to be dealing even less with the present type of case.
No, well, the human rights and refugee conventions are dealt with in other legislation. All this is drawing attention to is the residual sort of core discretion, if one likes, under the statute, whether or not to make removal directions where those issues presumably don't arise.
Well, it's actually giving instructions on applying specific paragraphs of the immigration rules.
Yes, that's right. And those paragraphs of the immigration rules apply, as I understand it, to the simple exercise of a discretion to remove in a case which isn't a refugee convention or a human rights convention case, because those are dealt with under other parts of the immigration rules, under other policies. But the point is that there is a broad discretion which the guidance requires to be exercised in the light of all the circumstances of the case. Of course, one has to exercise that discretion in the light of a range of other policies and in the light of a range of other rules. But here, just focusing on this, it draws attention to the need to take into account all the relevant circumstances of the case, including, at least in 2 or 3 cases, arrangements in the country of proposed destination and the possibility
really, you can't
of
construe the
enforceability.
statute, can it? I mean, we're a million miles away from anything that's actually relevant on construction. I mean, all you can say is there's a broad discretion. The question is, what are relevant factors? Or what's the discretion directed to?
Exactly. And what are relevant factors in any particular case can, in my respectful submission, be identified by guidance issued by the Secretary of State to his own decision makers. That would include considerations that those decision makers would have to take into account as a matter of public law. But then broader than that, as my Lord has indicated, one would then have to look at the statutory scheme itself to see what was implicitly required to be taken into account. And paragraph 81C, in my respectful submission, makes it crystal clear that what the decision maker is required to take into account, among other things, and indeed preeminently, is the identification of a qualifying country in the list at little 1 to little 4. So I do put the case mainly on statute, but since my learned friend drew attention to the guidance and that aspect of the discretionary nature of the decision, I replied briefly on it. And finally, no matter how narrowly one draws the decision that a person is to be removed, in my respectful submission on ordinary public law principles, it simply isn't a rational decision if, on the facts, removal cannot be effected, either for legal or practical reasons. The service of a fresh notice of an immigration decision when the Secretary of State makes another decision about the country of removal is, in my respectful submission, not, or should not be left as, a matter of favour and discretion on the part of the Secretary of State, but as a matter of legal obligation, because the selection of a qualifying country of destination is manifestly a relevant part of the immigration decision. And the court's been taken to the decision of Mr. Justice Ouseley, sitting as the president of the tribunal. That issue was also considered by the Court of Appeal in a case called MA Somalia, to which I think the court's already been referred. But if I can take the court back to that, it's volume 4. And it's tab 39. And it's paragraph 54. I mean, in paragraphs 49 to 53, Lord Justice Ricks rejected, or rather he accepted the argument that the decision referred to under 8228 is simply a decision in principle to remove from the UK. Paragraphs 49 to 53 bear reading, although I won't take the court to them at this stage, bear reading to see all the consequential cobbling together, if I can put it like that the court had to go through to make sense of that proposition in the real world. And then one gets to paragraph 54.
Which basically just endorses what Mr. Justice Ousley said.
Yes, that's right. But that convoluted scheme is simply not necessary if one embraces the proposition that the immigration decision itself is a decision to remove not just from, but to.
I mean, on your approach, the Secretary of State couldn't do what he did in USIF and apparently also in MA, and that is take the applicant's statement of the relevant country at face value, put it in case it proved correct, and then deny in the course of the hearing that it actually was correct, and indeed presumably state in his decision letter that he didn't believe that the applicant came from that country. That would all be impossible because you would say that the destination is essential part of any decision, immigration decision, and has to be not only genuinely believed but reasonably.
The notices regulations allow the Secretary of State to specify the countries or territories of proposed removal.
Yes.
So on our general approach, incorporating our approach to section 120, we would expect the Secretary of State to specify all the countries or territories of removal to which removal was a realistic possibility, including the country or territory where he himself believed the person to come from, but also the country or territory that they asserted that they came from, because that would then be looked at. That is still a realistic possibility, something that might be determined in their favour in the course of the appeals hearing. But our fundamental point about that is that doing that allows the appeal tribunal to get to the bottom of exactly where, if anywhere, a person can be removed to, where there is a reasonable grounds to believe that a person can be removed to, so that those issues are absolutely clear. Your Lordships can bear with me, I'm allowed. Oh yes. When I was taking the court to volume 4, tab 50, I drew attention to paragraph 4 and made some submissions about the relevance of section 67 after a successful appeal of the kind that we submit MS was entitled to. My submissions, I think, are consistent with paragraphs 27 and 28 of Lord Justice Sedley's judgment, just a few pages further on. I think that's consistent with my submission that the jurisdiction would be there in cases where Section 67 applied, but there would be a need, in the light of a successful appeal, for the Secretary of State to focus much more closely on whether he ought to grant leave to remain, and the background of the successful appeal would tilt the balance in favour, in an appropriate case, of a particular immigrant. And that is, in my respectful submission, as it should be. If an immigrant can establish that there is no realistic possibility of him being removed in the future, however one defines the future, he ought to be allowed to establish that in an appeal process, and he ought then to be allowed to ask the Secretary of State at least to consider, in the light of his personal circumstances, granting him a short period of leave to remain, so his position is regularised and he can work and form an ordinary part of civil society. That doesn't hugely prejudice the Secretary of State, because he can always decide, it's up to him how long a period of leave to remain to grant, and when that period comes to an end, he can refuse to renew it and make removal directions again. And that, in my respectful submission, is consistent with the basic structure of immigration control in sections 1 to 4, that either the Secretary of State grants, either the immigration officer grants leave to enter or the Secretary of State grants leave to remain, or there is removal. Unless I can assist further, I think those are my submissions.
Well, thank you very much. And I would like to thank both counsel for their submissions, where we shall take time to consider this matter.